Good morning, everyone. This is Mark Burgess. Welcome back to our WIOA Wednesday webinar series. We haven't had these in a few weeks, but we've got a good topic today that ties into many aspects of the new law. One aspect is the certification process for one-stop centers that is occurring right now. We are getting several of those in each day, and hopefully each of our local areas and the local boards will have those completed by the deadline of July 1. A main component of that certification is that equal opportunity and non-discrimination is in compliance. There's several criteria in the checklist for the application that we address EO. So what we're going to talk about today can be utilized to meet those criteria rather than conduct a new monitoring visit, or whether that be on-site or desk review. So we'll talk about that a little bit today. A little bit of housekeeping as we get started. If you're not familiar with our webinar room, we've got a few polls up there right now. So identify, if you would, who you're affiliated with, whether it be the board or one of our programs, or if you're an actual equal opportunity officer. Also, the other two are asking our EO staff would like to know where you are on a couple of the items that you have to do on an annual basis, both self-evaluation and your standard deviation report. So if that's something you do handle at the local area, please complete that, and we'd like to see where you're at so we know if there's some work we have to have done, or our EO staff at least have to have done to get back in and get these in compliance. On the left, you'll see the chat pod. You'll see everybody welcoming all of us. Thank you. And again, good morning to those just joining us. If you have a question or a comment during the presentation, please utilize the chat room. Either in the middle or at the end of the presentation, we will open up all telephone lines, so if you feel more comfortable asking the question via telephone rather than typing it out, you can wait till we identify when those points will be. And then finally, on the bottom left-hand corner of your screen is the files pod. If you don't already have the presentation, you can download the PDF there. We have had a couple typos corrected with what you'll see on the screen, but nothing of any major consequence, so I wouldn't print a new one if you've already got that in your email and printed it off. So we have three presenters today, all from our Equal Opportunity Office. Our Deputy Director, Miguel Calderon, Tim Galimo, and Randy Baschulte from his staff are both here also to help. So with that, I'd like to turn it over to Miguel to get the thing started, and I'll be pulling these polls down and out of your way here in the next few seconds. Thank you.
Good morning, and thank you for joining us on Webinar Wednesday. Today we'll be discussing monitoring for equal opportunity and compliance related to Section 188 of the Workforce Investment and Opportunity Act, or WIOA. As Mark said, my name is Miguel Calderon, and I am the Deputy Director for Equal Opportunity Monitoring and Compliance in the state's WIOA EO Officer with the Department of Commerce and Economic Opportunity. And today I'm joined by Randy Baschulte and Tim Galimo, who are the State Equal Opportunity Compliance Officers for DCEO. Currently, we make up the entire staff for Equal Opportunity Monitoring and Compliance, but we will be adding a new position in our Chicago office in the next 30 days or so. I'd like to take a moment and thank Lisa Jones and her team for providing us access to this platform to be able to provide training and give us an opportunity to interact with our partners in the LWIAs. EO training is an area that we've not been very active with in the last few years, so we're excited to have this opportunity. Going forward, our plan is to offer EO training on this platform in a quarterly basis, and we'd really like your feedback as to what type of information that you would find beneficial. So after today's session, if you wouldn't mind, please reach out to Randy or Tim and I with areas that you would like us to provide additional training on, and we'll look to develop content based on that. Our contact information will be available at the end of the PowerPoint presentation. Before we begin, I wanted to give everyone some information on my background since I'm new and the work that we've been doing with DCEO in the last few months. I started in DCEO back in November, and I've been an employee with the state of Illinois for over 12 years now, working for the Office of the Comptroller Emergency Management Agency, and the Department of Veterans Affairs most recently. My roles with those agencies revolved around personnel management, labor relations, equal opportunity, and affirmative action. Since joining DCEO and working with Tim and Randy, we've worked to create a new monitoring schedule, and we've initiated visits, which in recent times had been limited due to travel restrictions and budgetary issues. We had the opportunity to attend the Michigan Works EO Summit and meet with Roger Ocampo, who is the Chief of Compliance for the Civil Rights Center with the U.S. Department of Labor, and had an opportunity to discuss our MOU. We've since updated our methods of administrations. As I mentioned earlier, we established a new Spanish-speaking monitoring position in our Chicago office, which we will be posting here in the near term and hopefully have filled by the end of the month. We've created a central repository for all of the EOMC documents, so our monitoring reviews, investigations, etc. And we've updated the EO section of the DCEO website. So those are just a few of the accomplishments that we've had, and we look to build on that and continue to support our partners in the LWIAs. Personally, I'd like to attend as many as of our compliance monitoring entrance meetings as possible, which will give me an opportunity to meet with everyone and tour the facilities that we're working with. As I mentioned, our presentation today is on monitoring for equal opportunity monitoring and compliance. And before we start on the slides, I wanted to provide a quick overview of what our section's role is in that process. So our team completes the on-site compliance monitoring reviews at all of the workforce training centers operating with federal WIOA funds. The compliance review is conducted pursuant to 29 CFR Part 37. The implementation of the non-discrimination and equal opportunity provisions of the Workforce Investment Act of 1988 and the WIOA EO Policy Letter number 00-07. As a recipient of federal WIOA funds, the Department of Commerce and Economic Opportunity is responsible for the identification of and compliance with all aspects of laws, regulations, contracts, or grant agreements that could have material effect on the operations of the programs under its jurisdiction. The department is responsible for the establishment and maintenance of an effective system of internal controls over compliance requirements. With that said, I'd like to turn it over to Tim Galimo to begin our PowerPoint presentation. Many of you probably know Tim or have interacted with Tim over the course of time. He's been with the department for over 16 years now as an equal opportunity compliance officer. Tim?
Thank you, Miguel. Hello, everybody. It's really a pleasure to speak to all of you this morning. We've got some new information to share with all of you, and hopefully you can take the information and share it with some of your staff if they're not able to be present, and and be able to really get something out of the information that we share with you. So the very first slide that you'll see here speaks about the new requirements that were set forth with 29 CFR 38. And in particular, 29 CFR 38.51 sets forth a system for annual monitoring. And that's to ensure that each recipient is conducting its WIOA Title I financially assisted programs and activities in a non-discriminatory manner. At a minimum, each annual monitoring or review, as we call it, must include three different things. And those three things are an analysis, so a statistical or quantifiable analysis of records and data that are kept by the recipients, including analyses based on race, ethnicity, sex, limited English proficiency, preferred language, age, and disability status. The second major component will be involving investigations into any significant statistical differences. And that's to help determine whether these differences appear to be caused by discrimination or just some other factor. The third and probably most critical component is an assessment. And that assessment is used to determine whether the recipient has fulfilled its administrative obligations. And so, for example, like record keeping, notices of communication, the way clients are treated within and throughout the process of receiving training, and any duties assigned to it under the non-discrimination plan. Something that's brand new results from the rules being changed in the CFR, and it regards the governor now has complete obligation authority over the equal opportunity provisions of the law. So the new WIOA Section 188 regulations that were published in the Federal Register on December 2nd of 2016, and then later on became law, that was effective January 3rd of 2017, provides updates to the existing regulations, which really haven't been changed a whole lot since 1999, since the inception of WIA. So for Illinois, though, the important part that everybody can take away from this is that in speaking with USDOL, our methods of administration was grandfathered in to continue using the old regulations, more or less, because the date of our certification was February 14th, and the CRC knew that we would not have enough time to create a non-discrimination plan. So we have until February of 2019 to basically continue monitoring for compliance under the old rules and try to implement the new rules throughout the course of that time. The final rule's updated language ensures that the definition of disability will be really interpreted pretty broadly, and that will help enable more individuals with disabilities to be effectively served throughout the workforce system. The rule also addresses different accessibility requirements, and primarily those including information using electronic technologies and also service animals. There's been a big push to incorporate service animals for a variety of reasons other than just mobility reasons or reasons of health concerns. So the federal government is looking into expanding those roles and including that throughout the workNet system or American Job Center system. It also expands LEP. It's going to help ensure that individuals with limited English are informed about and are able to participate in covered programs and activities. Something that a lot of the offices already participate in, so those areas of compliance will be expanded. The CRC also revised the Equal Opportunity is the Law notice, or what you guys know as the poster. You'll see Randy and me basically go out and make sure that your postings are up to date. You'll be receiving new postings shortly. Miguel has been in contact with CMS, and Central Management Services is printing the posters as we speak. So we should be able to get those postings out to you relatively soon. The recipients are required to display those posters and to distribute them in order to ensure that any individuals participating in the programs and activities are aware of the scope of the non-discrimination and equal opportunity provisions of the law. And as the rule explains, the CRC has made translations of this notice available to recipients and approximately 10 or so most frequently used other languages other than English. So you'll be receiving a variety of large posters that have different languages on them. And not that each, for wall space concerns, not that each poster has to be posted, but at least you'll have them on hand for people who have difficulty or cannot understand English so they can participate in your program and know their rights. Now, with any annual analysis of data, DCEO will be looking for statistical or quantifiable analyses of records and data kept by the recipient, and that's under 29 CFR 3841. That's going to include analyses by race, ethnicity, sex, limited English proficiency, preferred language, age, and disability status. And as I've already spoken about, if there are significant findings within the analysis, an investigation into those differences and significant differences will be identified as in paragraph B1 of the regulations. And that allows for basically program activities and employment which is provided by all your recipients to determine whether or not those differences are caused by discrimination. This is something that's heavily emphasized, something we spoke personally about with Roger Ocampo when we met him in Detroit. And it's something that we'll be emphasizing as we come out and conduct our monitoring reviews. The monitoring reviews must focus on the effects of the actual implementation of policies and procedures on a group of people going through the system. So at each point, basically, it's going to identify decision points and examine the impacts upon various groups. Now, there's two types of discrimination, and those in the equal opportunity trade basically understand that there's disparate impacts, which are facially neutral practices or policies that have an adverse impact on a protected group. And that sometimes, based on race, sex, national origin, age, or disability, they'll lack substantial legitimate justification. So while those policies may not intend to discriminate, they do. The second is disparate treatment, and that's a lot more forward. It basically occurs when a person or persons are intentionally treated differently. And basically, those that are protected by the law can't receive different treatment just because of their protected status. Now, the statistical analyses that are basically new, we used to emphasize the 80% rule. USDOL decided that really left too much to be undiscovered. So they created a standard deviation formula. And standard deviation basically comes from a benchmark case that was titled Hazelwood School District versus the United States. And in that, Hazelwood had basically ongoing practice of engaging in discriminatory hiring of African American teachers. And so the Supreme Court compared the percentage of teachers in that district who were African American to the percentage of African Americans in the relevant labor market. And so they noted the disparity exceeded 6 standard deviations in 1 year and 5 standard deviations in the following year. So the court concluded that the statistical evidence reflected a gross disparity, and that was basically a pattern and practice of discrimination that they declared illegal. So the results from that are what now government agencies are gearing toward, including USDOL, to include statistically significant factors, and that the probability of any statistical analysis, the results must be less than a standard of 5%. So courts generally allow for a valid statistical inference of discrimination to be drawn when there's either 2 or more standard deviations out. The initial comparisons that we're going to be looking at when we analyze your area are going to include whites versus all others, any group over 2% in the population versus all others, males versus females, individuals with disabilities versus all others, each age group as reported to ETA versus all others, and then a separate analysis, and this is very understandable because each physical location, each decision maker, and each avenue of application needs to be looked at. The LWIAs themselves are going to be having to conduct statistical deviation analysis, and this will more than likely come up in future meetings that we'll have with all of the LWIAs, as we go through this process. I know each LWIA has received an Excel spreadsheet from us that has the standard deviation formula on it, and so it's kind of a plug and chug type of operation where you put in the information gathered from IWIDs, and then you go ahead and churn out the standard deviation number. From that, the local offices, along with the state, will look into why or what, if any, deviations do occur, and if they're significant. I'm going to go ahead and hand this back to Miguel to open up for any questions. Miguel?
Yeah, Miguel, it's Mark. We've got 3 questions coming in based on, and maybe Tim can answer as well, based on the statistical analysis. So the first one is, will you be providing templates to determine the calculations for this dynamic formula for statistical calculations? And I think really all 3 of these may tie together if I can read them all at once, because I think the answer might be that you're looking to, I know Tim mentioned that you're going to be having more webinars, and maybe that would be a mechanism for providing additional information, but I assume that there will be spreadsheets such as the Excel spreadsheet and others coming their way.
Yeah, how I concluded was basically each area has received, and this was probably about 3 years ago, an Excel spreadsheet that has the quantifiable analysis and standard deviation formula. If you have trouble accessing it or need a copy of it, we'll have that resent out to you. Or if you have any questions as to how to actually interpret the data, that's something we can also help out. Randy, Miguel, and I have all received training on the standard deviation formulas, and so that's something that, when the time comes and as you're conducting your analysis, your annual analysis, you can go ahead and report those findings. Some areas already report them via email. They send me the results, which is very helpful because then we can do a desk review here in Springfield and then depart with the information and talk to each of the local areas about what we found, and then maybe find rational explanations and sometimes irrational explanations as to why the resulting numbers occurred the way they occurred.
Somebody's indicated that maybe the last template they received was in 2013. Have you sent new ones, or you're going to send new ones?
The standard deviation formula, when we met with Roger Ocampo, it remained the same. There's no statistical changes that have been made. The only changes were in the law that emphasized the use of standard deviation over the 80% rule. I know all along all the methods of administrations that were conducted by each local office, they conducted their all their analysis is using 80% for the most part for a number of years, including the state. That practice has now basically come to an end, where we have to now use quantifiable data through the standard deviation formulas. So basically in a nutshell, it's just a shift of formulas. And from that, depending on how the resulting factors and the resulting reasons, we'll have to interpret that and then relay all that information as a group back to the Civil Rights Center for analysis. They expect that to happen throughout the years of 2018 through 2019 as we incorporate, because like I said, we've been grandfathered in, but that's not to say that we can't be, that they don't want us working toward that end.
Okay. So it looks like we've got some other commenters, Miguel, that they're going to be looking for some additional training.
Yeah, I saw that, and this is neat. I like how we get the live interaction. Definitely, and we can talk to Lisa about this, but I mean, we don't have any problems with trying to set something up here in the near term where we can do a specific webinar on this topic. And then we would be more than happy to send the spreadsheet out to everyone just as a, you know, it's been a few years, obviously, since it's sent out. So we could send that out, and then maybe here in the next couple of weeks or so, we can, if the schedule allows, we could set something up where we can do a presentation on it.
Yeah, we'll want to talk with you to see how that would lay out for a webinar format. Certainly, if there's documents that need to be shared, we can actually share screenshots and things like that, as opposed to just a PowerPoint,
Sure.
So that they can see where numbers are being entered into a spreadsheet and then making formulas, present outputs and that. So we can talk to you on that.
Yep.
and figure something out
Sure.
in the next few weeks. Now, there was one more before we go ahead and move on with the presentation. Is someone had a concern or question on when you speak to the all others group, are you talking about all others who meet eligibility guidelines or the general population?
I guess I need a little clarification.
Well, I think in your presentation you were talking about the statistical analysis comparisons, and you mentioned all others. So is it just all others within WIOA, WIOA, or are you talking the general population that is being compared against?
Like I said, so how the Supreme Court made their ruling, they have to look at the labor market. So the comparisons are in order to find out whether or not there's basically an impact, is you have to look at who's employed and who's employable. And that information you get from IWDS. You also get that information from the U.S. Census Bureau. And so, and the active participants, that data is fairly easy to get a hold of through iWIDS. I know there's been some trouble spots because our agency used to collect more data on people who are basically inquirants, registrants, people who aren't in the system yet but are trying to use basic or core services. And there's a lot of areas that aren't collecting that data officially, and it's not really showing up on iWIDS. That was something that we were actually trying to work with at the time with Jerry Eward before he passed away. And so DCO is aware of this type of information that is necessary to sometimes do the quantifiable numbers that you guys are going to need. It's something that USDOL is now enforcing, so we're going to have to come up with a way to actually come up with those numbers.
Okay, so our last few comments, and we'll turn back over, are that they would really like to see some in-person training. I think we'll discuss that, maybe start with a webinar just to get some basic information and still see if there's an in-person training needed for all of you. Not to say that won't be considered. I don't want to speak for Miguel, but certainly, as we all know, there's a budget issue, and traveling to 26 local areas to provide training, or even asking 26 local areas to travel to one one facility to get it all at once would be a potential concern. So internally, that'll be discussed, and Miguel can get back to everyone on how that training will occur. But it may be either have to occur webinar because of the travel restrictions, or maybe a combination of both. However you feel best, Miguel.
Yeah, we'll definitely have to take it into consideration, see what would work best. But I just think in the near term, a webinar format would be first, but I definitely agree an in-person where we have some more interaction would probably be the best.
Okay.
For everyone's understanding. So with that said, we're going to turn it over to Randy Basanti. Randy, he's been with the Department of Commerce and Economic Opportunity for 14 years now, believe it or not, and in 12 of those years he served as a EO compliance officer. Randy?
Thank you, sir. My name is Randy Basanti, and today I'm going to talk about four slides. The first slide is going to be about the monitoring requirements, as you're going to see before you, then the responsibilities, who we interact with, and how we implement the EO ADA monitoring program. First, let's start with the requirements, the monitoring requirements, that is. First of all, as you look at the slide, you see regulatory guidance. That's a given. And the guidance that we extract from or use is found in 29 CFR 3738, also under Section 188. Now, like I said, that's a given. That's from the CRC. We also utilize the living document that we produced, the MOA, soon to be the Non-Discrimination Plan. And we also use guidance from OET and other DCO agencies. Okay, as we move along, we have a chain of command. We have personnel with specific responsibilities in this state who work with the WIOA program. Then we have local plans and programs, and we have a robust coordination and interaction with all of the parties involved. We also deal with the leadership and the administration of DCO and the workforce agencies. And then finally, I'll tell you how we do, in fact, implement the monitoring program and how we do, in fact, maintain records. First of all, the assigned responsibilities. There is, like I said, a chain of command, and they're the ones who have certain responsibilities for the maintenance of the WIOA program and how things get done. Okay, let's go. It begins, next slide. It begins with the governor. The governor has oversight, monitoring of the state's WIOA program. He's liable for all of our actions and grant activities and the development and implementation of the MOA, soon to be Non-Discrimination Plan, and compliance with all of the regulations. Now, that's a lot of responsibility. So what the governor does, in essence, is he delegates that authority to the director of DCEO, who has overall overwatch authority for the WIOA program. And the DCO director, just like the governor, he has a lot of responsibilities too. And what he has is two capable deputy directors who, in fact, provide the underground administrative training and investigation and resources that he really needs to run the programs. First, you have the deputy director of EOMC, that's Miguel Calderon. He's responsible for the administration and of the EO and ADA program. In addition, he's responsible for training us and the staff and the people in the workforce areas. And if, in fact, there were discrimination problems, he's responsible for conducting investigations. Then you have the deputy director of OET. I had ETA on there, it's OET. and that's Mr. Rodriguez, and he's responsible for the administration and the training and the funding of the various programs. What happens here is that he, in fact, is responsible for the funding of our travel, our training, and tip and mine salaries. And then we have the local area CEOs, the WIBs, the executive directors, the EO officers, and what I don't have on there, I'll say some of the case managers and so forth, because they are the ones who first meet the clients that we, in fact, deal with. The CEOs and the WIB, these are the key leaders, and we mostly deal with the directors and their EO officers. Okay, who do we interact with? Slide 9. As you see there, the CRC provides us with guidance, policy, regulations. They also provide us with training, EO administration, and if we run into problems where we cannot conduct an investigation, they would conduct the investigation. Another thing is they also allowed people to directly lodge complaints with the CRC if, in fact, they didn't want to talk to us. Next people that we do, in fact, interact with would be the WIA directors and the EO officers. Keep in mind, we just do not jump up on any given day and say we're going to go to a certain WIA to conduct an investigation or monitoring or anything. What we have to do is plan our monitoring visits. And our planning begins, first of all, with our deputy director, and he gives us our marching orders as to like where we should go and what we need to do. If, in fact, there was a problem in the WIRs in terms of investigation and stuff like that, we would do that too. We also answer questions if, in fact, there were questions. We also look for reports, the quarterly reports, the annual reports, and we also conduct surveys. Next, we have our partners, like the colleges, universities, State Department of Human Rights, the State Attorney General, and CMS. Those are, in fact, our partners. We also interact with our clients. If in fact, they have a complaint, they do call, and they will write, and they will complain if, in fact, there was a problem. We also coordinate with the DCO staff for EO purposes, and not only that, too, but for logistical purposes. As we prepare to our MOAs and so forth, or if we do have legal issues, there is a legal department. There are other people that we do, in fact, coordinate with, but these are the main ones that you see that we do interact with. The next thing is, and this is the most important, is how do we implement our monitoring program? First of all, we follow the regulations, as you see there, 29 CFR 38, also 37, Section 188, and several others. We also follow what's the living document in our MOA and so forth. That's what we do. That's a given. Now, before we go out, we have to prepare for the monitoring visit. And this begins with our deputy director, Miguel Calderon in this case. And he would give us our marching orders based on needs of what's needed in the workforce areas and so forth. And we would discuss this with him, and then from that we would prepare, say, like a monitoring schedule. And once we coordinate the visit, then we would prepare, or planning, then we would prepare, say, and the announcement letters, and as you've seen them before, they would include such things as what and when we're going to be there, and this is sent to the leadership of the workforce agencies. We check like EO communication notices, we check assurance clauses in your contracts and so forth, and I know that's done by the fiscal people. We would check the EO and ADA policies. We check your file for the history and reports and complaint allowance. We check your record keeping. We check to see if you do in fact visit your contractors or your providers, and you should have files of your visits in your record. We check your complaint procedures or corrective actions sanctions if you had any, and we check your strategic plan. Now this is unusual, I think sometimes people don't know we do this, but we check the strategic plan beginning first with the executive summary, and what we do in there is we check to see like what the leadership attitude is towards the local needs in terms of minority groups, people with disabilities, people with language barriers, women and other minorities. In other words, we are looking for inclusiveness when we check your strategic plans. Another thing that we do, we check demographic data, we check the self-evaluation reports, we check the census data, and also a couple of other things we check would include, say, your 508 computer website accessibility. And that's an easy check to do because I could do that from my desk before I visit you. We use that cynthiasays.com. We take your URL and we would put it into the data box in Cynthia Says, and they would check your computer system to see if in fact your website is accessible. Another thing that we do, that we get from you, is you would give us the locations of all of your sites, your affiliate sites. And if in fact you do have new sites, we will conduct facilities assessment. And also, we check your past files for a possible relook. We check with the director or the EO officer to see if they have any input if we had findings. And from that, while we're there at site, we would say, prepare somewhat like a quick draft as to like what our findings were, and we would discuss if in fact that there were reclaimers to what we found that didn't go along quite with the regulations or something like that. You could reclaim that or make corrective actions. We check your records and reports, and we're required to keep records for 3 years. And then once we leave your site, then we coordinate our findings with the state WIOA EO officer, that again is Miguel. And we would discuss, and then we do say somewhat conduct follow-up actions if in fact there were findings. Now, monitoring is not exactly a science as such. You just have to be knowledgeable of the rules and regulations, and that when we do in fact come on out, we just there to ensure that there is in fact compliance with the policies and procedures. And if in fact you have questions you would ask, you tell us what you need and we'll find a way to work with you. And with that, I'd like to be followed by Tim Galimo.
Thank you, Randy. Randy and I have worked so closely over the years that we can basically pick each other's brain and know what each other are thinking at any given time. But I just wanted to go ahead and continue with what the basis of the discriminations are going to be now that the new laws have passed. They've included some updates to it. Section 188 of WIOA contains provisions that are basically identical to Section 188 of WIA, but the rules updates also enhance the system. So In particular, for people with disabilities, individuals with limited English proficiency and transgender individuals who may face various forms of sex discrimination, and individuals who are pregnant or have had a child or some other medical condition from that. There are safeguards basically in place to protect those persons as well as people who are limited English proficient. These steps may include oral interpretation and written translation of both hard copy and electronic materials into non-English languages. This will ensure that individuals with LEP are informed about or are able to participate in covered programs and activities. In addition, the rule clarifies which documents are considered vital. The definition basically for vital is any necessary information for an individual to understand how to and obtain any benefit, service, or training. This vital information must be translated into languages spoken by a significant number or portion of the population eligible to be served or likely to be encountered. So we're going away from an MOA and we're going to create what's now known as a non-discrimination plan. There used to be 9 elements. I think everybody who's worked with the methods of administration understands the 9 elements as such. But the goals for the non-discrimination plan really haven't changed from those elements. Basically, the goals are going to include local needs by marketing and outreach, involving community groups and schools, effectively collaborating with partnerships and linkages for intake, registration, and orientation, staff training, assessments and screenings, and service delivery. Now, each governor is required by the regulations to establish 2 kinds of systems. At a minimum, a system for annual monitoring of all aspects of the recipient's clients with regards to WIOA, and in addition, a system specifically for the purpose of determining recipients' compliance with WIOA's non-discrimination and equal opportunity provisions. So governors are not released from the responsibility just because they designate a person at the local or state level to oversee these monitoring responsibilities. The governor's oversight responsibilities include ensuring compliance with the non-discrimination and equal opportunity provisions of WIOA, and where appropriate, negotiating with the recipient to secure voluntary compliance when non-compliance is found. According to the CFR, the governor and the recipient are jointly and severally liable for all violations of non-discrimination and equal opportunity provisions of WIOA unless the CRC director determines that the governor has demonstrated a substantial compliance with the requirements. In such a case, the CRC director may recommend to the Secretary of Labor to waiver a sanction against the governor. The CFR imposes specific requirements for complying with monitoring responsibilities. Each EO monitoring review must include a review of each recipient's programs and operations to determine if the recipient is complying with the administrative obligations under Section 188 of WIOA. These administrative obligations are designating the Equal Opportunity Officer, the notice and communications, and the assurances we spoke about. The recipient is also complying with the responsibilities assigned through the non-discrimination plan, and whether or not discrimination is occurring in the operations of the recipient programs and services. So as you can imagine, the last part is basically the heart of the monitoring review for equal opportunity and non-compliance. Now, there's preliminary information that's essential, and basically under 29 CFR 3835, we're going to ensure that a copy of the EO notice is in the employee files, the client files, the applicant files, so on and so forth, that there are Babel notices which will include definitions on all web pages, that there will be a data collection and affirmative outreach, and that the governor's responsibilities under Subpart C will plan to review local non-discrimination plans, updates of monitoring reviews, and, of course, annual monitoring. Now, the state level EO officers and also the recipient EO officers under 29 CFR 3828 will help to develop compliance assistance materials. And so with the help of the local EO officers, we're going to come up with training plans both in person and as well as for conferences. And I know Miguel has already spoken about that previously, but that's something that's already been included in what we're going to be calling the non-discrimination plan. I'm going to go ahead and let Randy handle the next series of slides, including the desk review. Go ahead, Randy.
Okay, thank you, Tim. I'm going to talk about 4 slides: the on-site review, the specialized tools that I use to conduct the reviews, physical accessibility, and information access. Okay, the on-site review. The purpose is to determine compliance with equal opportunity and non-discrimination requirements and review significant differences or disparities. What that really means is we're there to ensure compliance. We're there to help you to comply with the rules and regulations. If there are findings, we're there to show you where to look and how to make corrective actions. We're there to give you an opportunity to fix findings if possible and to set a time for corrective actions. The entrance briefing conference. This is self-explanatory. What we do is we meet with a director, an administrator, or local EO officer, and this is to discuss information on the announcement letter and set the scope of the review. We make arrangements for workspace, and we begin first by looking at your MOA with all of the attachments for each of the elements. We also conduct surveys. We conduct client surveys, and we conduct staff surveys. The staff survey is intended to see, to check the knowledge of your staff that has to do with EOA, your MOA, and anything that has to do with equal opportunity. On the client survey, what we do is we check the quality of your program as it impacts on the clients to see how effective your program is and how they feel about your program as such. And we also check, after we get through with the surveys, oh, by the way, the surveys are voluntary, and none of the information gleaned from the surveys are used in anywhere to affect what type of services that particular client gets. Then we move on to the file reviews. We would say select a certain number of files and go through the file to check to make sure that there was no confidential or classified materials in the file, medical information in your files. We also check those files to make sure that any file that had confidential medical information was separate from the regular operational files. In addition to that, those files have to be secured and in a locked container, and that the only people who can see those files would be the case manager, the executive director, emergency personnel, and people who conduct inspections such as myself or the CRC. Also, as a part of that entrance briefing, we establish points of contact. In some places where it's only one site, that's no problem. But some places you have anywhere from 12 to 13 sites. And we need to get names and phone numbers and addresses. We have to verify that. And then also, we moving right along, we check the demographic data and discuss the data analysis. We also check your assistive technology and resource rooms. One of the things that came on up with the assistive technology is that much of the assistive technology is obsolete. And we try to assist you in finding ways to replace that obsolete technology, and that could be a topic for another time. Then after all that is done, myself, I conduct a facilities check using that 19-page checklist. And like I said, that'll be coming on up at the what I do with my tools and the physical accessibility check. I check your marketing outreach program to see if it's effective and if it's inclusive, and it includes the demographics in your surrounding areas. I also check your bulletin boards, your monitoring program. Remember that I gave you that provider's checklist, and that's what I'm looking for. I'm hoping that you used it, and it should be on file. I also check your reasonable accommodation policies and your LAP programs. Your LAP program could be kind of cumbersome, but the recommendation is that you coordinate with some of the local demographical group and establish points of contact so that if in fact you do need an interpreter or some type of language need, that you could call them there. I also check to see, and this is new, if you have a plan for guide animals. Now that's new, but you should have a plan for guide animals. I check your complaint files, and you should have 3 years worth of records. And lastly, what I check on site is your taglines. Now, monitoring is a process, and it requires for me and you, the application of the regulatory guidance. I check your policies and your procedures and your facilities. I talk with you and you show me what you have in terms of the MOA, the attachments to the MOAs, your applicant files. Again, show me your facilities. I check your outreach programs, your bulletin boards, and your special programs. Then you can tell me what you need to know about problems that you might have. Then you need to show me how you run your program. Those are some of the things that I look for in the monitoring process. Now, before I conduct any monitoring on any site, I have to have my tools. I have specialized tools. There are 4 that I rarely use. It used to be 6, but I have a 30-foot special data tape. I have a pressure gauge that I check doors. I have 2 levels. One's 24 inches, one's 48 inches. And depending on where I'm going and the type of measurements I need, I will attach that smart digital tool to each one of those levels to measure like slope angles and so forth. And I use a measuring wheel if in fact there is a lot of data to cover. I see that up there. Thanks, Mark. And if in fact you need that stuff, you could Google East Lake Dairy and Associates, LLC. And they could talk to you about those tools, and they could tell you the price. It's not expensive. The most expensive thing up there would be the smart tool, which runs what, $100, something like that. But these are the tools that I use when I go to measure or to assess a site. Okay, physical accessibility. Your programs have to be programmatically and physically accessible. I'm checking the physical accessibility part. Now, as I look at that slide, I could tell you right off the bat, I could do the first 4 or 5 items just by looking as I pull on into your parking lot. As I look at your parking lot, I'm looking for the marked spaces, and the proper signage. Okay, here we go. For the older sites, that I already have on record and so forth, the parking signage should consist of a fine sign and the accessible sign. The fine sign, the bottom of the fine sign should be, for the old lots, should be 48 inches off the ground. And for the new facilities, according to the IAC, the Illinois Accessibility Code, it should be 5 feet off the ground because people are using bigger vehicles and I need to see these signs. Also check your walkways and your sidewalks. The sidewalk should be at least 36 inches wide. It should be like concrete or asphalt, and it should be no ruts, and it should be relatively flat. I check your pedestrian and curb ramps. Your pedestrian and curb ramp should be at least 36 inches wide. Most are larger. And for the pedestrian ramp, there are certain requirements which would be found in the Illinois Accessibility Codes. There's a whole lot of standard requirements for all these things I'm telling you about in the Illinois Accessibility Code. I'm not going to get into that because we could be here for 2 days. Then, as I approach your entrance, I'm checking your doorways for the width. I'm also checking the threshold for the height. The threshold at the exterior door should be no higher than 3/4 of an inch. We like to see it lower. We like it to be, say, like around 1/4 to 1/2 an inch, but sometimes that's not always the case. But it should be no higher than 3/4 of an inch. The width of the door, with the door being held at a 90-degree angle from the face of the door to the molding on the opposite jamb, should be no less than 32 inches. The weight of the exterior door should be 8.5 pounds. The interior doors check the same way. The interior door should be, the weight should check no greater than 5 pounds. Then as I get past your doors, I'm checking the corridors and the alleyways and so forth. They should be no less than 36 inches. As I'm checking your corridors, I'm checking to see if there are, in fact, obstacles in the corridor. Also check the walls to make sure if you have items hanging off the wall, protruding objects, that are no more than 4 inches away from the wall. Once I get done with those and I annotate those at my facilities assessment checklist, like I said, 19 pages, I then go check your restrooms, your water fountains, and your public phones. The restrooms, it takes a little bit of time, but they are requirements that's already outlined in the Illinois Accessibility Code. The important things that I'm looking for is the weight of the doors, the signage on the door, the height of your commodes, and if you do in fact have a urinal, say in the men's room, that is no higher than 17 inches off the floor. I check your faucets and so forth to make sure that either you have levers or you can compress it and the water runs for about at least 10 seconds. But mainly it would be better off if you had levers. And also check under the sink to make sure that the wrapping of your pipe does not, it's wrapped and will not burn a client who's in a wheelchair. And then under that sink, it should have a knee height about 27 to 28 inches. And I also check the countertop height, which should be no more than 34 inches. And all this is listed in the Illinois Accessibility Code. Then I check your water fountains, and believe me, there are rules for the water fountains also. The height of the water fountain should be no more than, say, like 34 inches. And say, like for those that they have pressure controls and so forth, the weight on that pressure control should be no more than 5 pounds or less. The flow of the water from the faucet should be at least 4 inches for sanitary purposes. I check your public phones. Now, most places do not have public phone for various and sundry reasons, but if you do not have a public phone, you're obligated to provide the applicant or the registrant with a phone for official use, and most people do. Okay, then I also check your tables and your work surfaces. Table height should be somewhere between 30 and 34 inches, and then the knee clearance should be somewhere between 27 and 28 inches. And that's what I check for the facilities. Like again, I use the Illinois Accessibility Codes and I conduct my measurements. Next slide. The information access, this is also important. And there are some good nuggets of information here. First of all, the alternative formats. We're talking about Braille and large prints. We have computer programs like Nextalk and DragonSpeak and so forth. We also have CART, Communication Access Real Time, for people who are deaf and hard of hearing. We have audio and video type materials, CDs and DVDs. In other words, you should have some type of a library for trade type material. We're talking about trade magazine, journals. We're talking about maybe even the Wall Street Journal. You're talking about manufacturing, engineering type references, standards and poors. We also should have, say, like magazine like Moody's Credit Ratings and Fitch. And all this should be part of your library. Yes, it's expensive, but there's a way to get some of that stuff free. In other words, if you have friends at your some of your business bureaus, they update their information annually, and you could probably check with them and get their older ones. And believe me, there's not that many changes in the older ones that you could have. Okay, sign language interpreters. You should have sign language interpreters, and it's best to keep a list of the sign language interpreters on hand. Locally, you could start with the Jacksonville School for the Deaf and Hard of Hearing. They do have information about sign language interpreters and how you could get a hold of sign language interpreters. You look at your office equipment, the controls. The control should be no higher than 34 inches in case you have an employee who is, say, disabled, or maybe some of your applicants who might want to use the office machines. But my recommendation is best that you provide a person in the office or the resource room to work the office machine for safety's sake. And again, the equipment should be easy to reach and 34 inches off the floor. We talk about some of the assistive technology that you have available from even week 1 and week 2 that's still usable. Maybe some of those enlargement screens could still be used. But it's best if you could buy some of the newer stuff. I could talk to you about some of the assistive technology and how to get rid of it, how to replace it, but that'll be a topic for a different time. I also check your market and outreach strategies. And your market and outreach strategies should be inclusive and is designed to, say, so that you could reach some of the various demographic groups who are usually not served. And then your transportation. Many places have arrangements with the local transportation agencies to have, say, like public transportation running directly in front of or close to their agencies. And it's one of the things that would be helpful for people who cannot afford transportation, that you would do something like that to coordinate and negotiate with your local people to arrange for transportation. I think that's it for me on information access. And with that, I'd like to turn it over to Mr. Calderon, who will talk about the review and participation.
I think we've got a couple questions while we're on this before we move over, if you don't mind. You spoke about the accessibility report. Is there a new version of that available? And if so, could you share that with all the EO officers and administrators in the field?
You're talking about the facilities?
Right, the accessibility, yep.
Yeah.
Okay, so if there's a new one, if we wouldn't mind, they're asking to have that. And then the last thing, is there a list of formats and materials available?
Hold on, let's get back to the facilities accessibility report. All you have to do is just text me and tell me you want it, I'll send it to you.
Okay.
Another format, you said?
Right, is there a list of formats and materials available for accessibility in the facilities that are acceptable?
Like, you talking about like Braille and stuff like that?
Joanne, if you...
And it's in all the computers and stuff like that, so like, if in fact you want to have...
Software and websites. If we could just get something like that put together.
Could you answer that?
Yep. We'll go ahead and get that out to everybody. So we'll do our best to gather that information, Joanne, and send it out. They just want to make sure they have the latest versions.
Yeah.
And that's successful.
Yeah, I think what we'll do is this, based on the questions that we've received today in terms of what information is needed, we can put it all together in one email and just send it out collectively.
Yeah, Joanne, you could email me and tell me what you need, and I'll get it to you.
Yeah. So we're in the home stretch here. So hopefully everyone's still awake on the line. But we've obviously had a lot of information that we wanted to put out regarding our monitoring process, and hopefully everyone's found it beneficial. These last few slides revolve around the review of the participant files, our on-site interviews, the exit conference, and report and follow-up. So in terms of the review of the participant files, the key here is that we look to see if the LWIA imposes limits with pre-employment or training pre-enrollment inquiries to those permitted by and in accordance with Section 504 and the Americans with Disability Act. And as Randy had touched upon earlier, of most importance, the state of Illinois must ensure the confidentiality of medical information provided by registrants, applicants, eligible applicants, registrants, participants, employees, and applicants for employment per 29 CFR 32.15. Next slide. When we conduct our on-site interviews, the procedures revolve around reviewing recipients' policies and procedures to ensure they do not violate the prohibitions outlined in Section 188, specifically 29 CFR 37.5 through 37.10. The review also includes an analysis of previous written reports prepared for each review. These reports must provide, among other things, the results of monitoring reviews and any corrections that have been made. The interviews include participant involvement by the sub-state level EO officers in conducting reviews for their on-site reviews. The LWIAs must need to provide the state of Illinois with the names, job titles, and the WIOA organizations in which these persons are employed. During the exit conference, all the monitorings end with an informal get-together with the LWIA staff to discuss potential findings and to clarify issues. This helps the monitor and the recipient understand what has occurred during the review process, so there are no surprise findings or areas of critical importance that have been left undiscussed. So I mean, clearly the point here is we don't want to blindside you with anything that you may not have been aware of. And then lastly, our report and follow-up. This is our last slide. With regards to follow-up, the state expects to be able to come back to the following LWIAs and conduct ongoing reviews that include the schedule of reviews and criteria for targeting recipients for review, monitoring instruments used by state and or sub-state level staff to monitor recipient EO activities, and policy issuance and procedural guidance regarding monitoring review and recipient evaluations. a representative sample of reports of monitoring reviews, including finding, results, form reviews, and the status of follow-up actions. So that concludes our PowerPoint presentation. On this last slide here, you're going to find the contact information for Tim, Randy, and myself. And like I said before, I mean, there's a lot of information that we put out, but clearly if there's some questions.
Yeah, Miguel, I noticed we have some individuals representing some of our other partner agencies, core partners from IDS and Department of Human Services, specifically Rehabilitation Services. And so I would like to see if they have anything. So Chelsea, can you open up the phone lines? And while we're waiting for those to occur, and if we want to see if they have any comments they want to add, it kind of leads into one of our questions. And the question was that each area is required to submit the WIOA contractor / provider EO / ADA evaluation on each of the sites they visit to DCO. Can we have access to that list so we are not visiting sites that have already been monitored in the last 3 years? It seems that if each area is submitting their own providers, we will have everyone covered. And I think one of the big issues going forward, and why I want to give the opportunity to other agency partners is other agencies have EO responsibilities as well. They may have their own director or deputy director of EO, and so they're doing the similar things as what the Department of Commerce is required to do in Title I, and so it is an issue of not duplicating that. And so moving forward, we really need to figure out a way, especially for certification purposes, that we aren't duplicating. So if someone is coming in for certification in 2017, but the DCEO version of an accessibility wasn't done for 2.5 years, but one was done somewhere else, would that be acceptable? So I think it is a discussion. I want to first give an opportunity to Al, to Doug, and to Quinetta, if any of you have any comments to make with regard to your coordination of services.
This is Doug Morton from DHS Rehab Services, and well, first of all, I'd like to say this was, I think, a very good overview of accessibility issues and the kinds of things that you know, they should be looking for, and a very experienced presenter. I appreciated that very much. I appreciated the fact that they, you know, discussed the website accessibility, which is, I think, getting a lot more attention these days. It's also something that there are a variety of tools to be able to test that accessibility. So that's something that's getting certainly a lot more attention these days. I also appreciated that the presenter mentioned that some of the assistive technology devices and equipment being found out there are obsolete, and we certainly concur with that. State government tends to have periods where we can come in and spend some money, and then periods where we can't spend money. And so there is technology, I know, that's kind of past its best functioning point. We do have a rehabilitation technology unit in the Division of Rehabilitation Services, and we would certainly be willing to consult with anyone in the workforce system who wanted any consultation on assistive technology or computer accessibility. That's a resource that we have, we can make available to people, and you know, hopefully that could be a contribution on our end.
All right, thanks, Doug. We appreciate and thankful that you found this valuable, and hope that all others did. If Al or Quinetta don't have any comments, we will work from an agency standpoint to determine the best solution for the assurance that everyone is getting monitored appropriately, but not overly monitored because of multiple agencies trying to do that. And certainly we all have our own rules that we have to abide by, and so unless and until discussions are had to change those, we are kind of working without our own guidance, and so we hope that everyone respects that until we can do a better job. And Quinetta, thank you for at least indicating you've enjoyed the session and don't have any further comments. We are starting to run on. Brandy, if you've got a comment to that?
Just a quick comment on one of the questions before, and I think it would address something that Kim was asking about, in that multiple agencies using the same provider. This is what I would recommend, Kim, is that when you visit or call that particular provider, if you would inquire at that particular time that you visit or call, who else is using your services. And once you get a name or an agency, call me, and if I have information like one of those provider listings, then I could check. If I don't have one, then I'll let you know. Then you would have to do, in fact, conduct that provider monitoring.
Yeah, and I think Rory just kind of mentioned what we were in the same thought of basically a training provider, whoever takes on that training provider. So if a training provider, and I'm just going to throw numbers out, in LWIA 5 requests to be added to a list, but LWIA 5 rejects that for whatever reason, and it may not be a negative reason, they just may not have any need for that training provider at that time, and LWIA 6 wants to pick it up because they have customers and a need for businesses in their area, then really it is a LWIA 6 responsibility because they're the one taking on the training provider in that sense. Now, what Rory said is the follow-up to that, to say hopefully all of our local areas, especially when we're working near other state borders and we're talking with other states, are working together to make that the most efficient and effective solution. And so you may have to trade back and forth to say, it's located in your area. Could you please do the survey, and then we'll do some in our area that you've requested to be put on the list as well, or vice versa. And when you're working outside of states, with our border states, it could be the same way where, and this doesn't apply only to accessibility, but we talk about this also when we're talking about eligible training providers and other things that are required to be reviewed for eligible training providers. We discussed that, and we've had that in webinars past where we've said the same thing. You just have to come up with an agreeable method, but if you, to put it, I guess, in a frank term, if you take on the training provider by approving it, you're responsible for all of these requirements to ensure they're complied with. And so, and you should have some kind of policy that states this. We've talked about, policies across state lines and what those might look like. So that, it seems like we kind of all have that similar understanding. We just want to make sure that everyone has it somewhat formal. I know a lot more discussions coming in on this matter in the chat pod, so we can all read that, and we'll ensure that, as Miguel said, he'll put all the questions and responses into a document and share that with everybody. So we'll take into consideration all of these comments and add them as necessary. I just had one more question that came up that I wanted to address before we sign off for the day. We're running out of, near our end of our time that we allot to these. The methods of administration, or the plan, non-discrimination plan as it will be called in the future, will be uploaded to the e-policy portal. We're working on that now. We'll add all of the attachments to that so that those are available. Now, Miguel, correct me if I'm not correct, understanding this, but in the past, as someone indicated, the state did not mandate they have their own specific methods of administration. They could adopt the state's methods of administration, and I think that still is in place. However, I think everyone should understand that document isn't written to be to work for 26 local areas as is. I mean, you have some input to put into those attachments. You have some, but if you want to use the basic format and individualize it to your local area and your local board, then that's really what could happen. Now, if you want to go beyond that and add some additional criteria, certainly you can start with the state plan, individualize it, and add to it as necessary. But certainly the intent is not to create more work for local areas than they need to. If the state plan works for you in the majority of areas and the individualized information added to it complies, then that's really all you have to do. So with that, Miguel, Randy, Tim, thank you so much for joining us today. We will coordinate all the information and ensure that it gets out to everyone, and then we'll work with you to get future webinars and also, if necessary, in-person trainings going to all the local areas, the EO officers and administrators, so that they can get all of their questions answered, especially it seemed like with a lot of the data that they need to understand going forward. So again, thank you. Thank everyone for joining us, and we will make announcement of the next webinar at least a week in advance of that. Right now we do not have any scheduled in the next several weeks, but you will get notification of that once we do have any of those scheduled, and it may be one of these EO sessions that we put out there in the next few weeks. So again, thank you, and all have a good day.